All right, welcome back. Thank you so much. Please be seated. Folks, as I discussed, we'll now begin final closing argument by the state.
Thank you, Honor. I wanted to, before I got going, really, I wanted to briefly respond to just a few things about the charges in the indictment and the elements that need to be proven beyond a reasonable doubt. Where'd the microphone go?
To your left.
Oh, sorry, I realized it wasn't over here. I want to talk to you about the elements of aggravated assault. So, Mr. Willis is absolutely right as far as with aggravated assault, basically you either have to prove an intent to injure or that someone was in reasonable apprehension of receiving injury. You can do either or. You can think that one happened, you can think that both happened, either that there was an intent to injure or that someone was in reasonable apprehension of receiving injury. In this case, there's both, and I want to explain why. We already really talked about the intent to kill with the malice, right? So the intent to injure in this case was the fact that she walked up to the door, put the gun right up to the door, fired in the direction of Mr. Barron. The difference between the intent with the aggravated assault and the malice murder is that with aggravated assault, you don't have to prove when she did that she intended to kill, just that she intended basically to strike her target. Whether or not she actually did isn't the question, it's just whether there was the intent there. When she walked up to the door with her gun, placed it 6 inches from the door in the direction of where Mr. Barron's standing and fired, if when she did that she had the intent to injure. That's one way you can find the aggravated assault. And or, meaning you can find that and the other way, or just reasonable apprehension, you can find that Mr. Barron, what she did when she walked up to the door, held it up to the door, and started yelling, "I'm going to shoot the door, I'm going to shoot you, I'm going to shoot you." And the thing with that is, Mr. Willis is assuming what she said was, "I'm going to shoot the lock off, I'm going to shoot the lock off," because that's what she says that she said, right? Like, we're just assuming she was saying, "I'm going to shoot the lock off David, I'm going to shoot the lock off David," because she says that's what she was saying. What we know is she's yelling something that has Mr. Barron scared enough to be hiding behind the wall. What I think that the evidence shows is she's yelling, "I'm going to shoot you. I'm going to shoot you. I'm going to shoot you. I have a gun. I'm going to shoot you." Maybe she's yelling, "I'm going to kill you." She's yelling all of these things that has caused Mr. Barron to literally hide like this behind the wall. That's reasonable apprehension of receiving injury. He's terrified. Ladies and gentlemen.
Judge, I have to object to she didn't tie it to the shot, which is the allegata, so I object to her explanation.
Without commenting on the evidence, the court is not commenting on the evidence. The lawyers have a certain amount of discretion as it relates to their argument, and I will authorize said argument.
That's reasonable apprehension of receiving injury, ladies and gentlemen. Is David hiding behind the wall while she's yelling, "I'm gonna shoot"? Why else would he be hiding behind the wall if not because she's yelling that she's gonna shoot him? That's reasonable apprehension of receiving injury. The judge is not gonna tell you whatever Mr. Willis said about the time between the bullet leaving the gun and hitting Mr. Barron. That's not what the judge is gonna read you. You will not hear the judge say that to you. That's what Mr. Willis wants you to believe. That's his argument. He has every right to argue that to you. You're not going to hear that from the judge. And I want to make that very clear. What the law requires is that Mr. Barron be in reasonable apprehension of receiving injury from the defendant's actions.
Judge, I re-object to counsel's explanation of the law being factually inaccurate.
Objection is noted. Continue.
So I wanted to make that very clear to everybody. As far as the criminal damage to property in the first degree, it's a property crime that places someone's life in danger. That's what makes it criminal damage to property in the first degree. There's something called criminal damage to property in the second degree that's just damaging property. If I took Ms. Bagwell's phone and smashed it on the ground, that's what that is. what criminal damage to property in the first degree, and the reason why this statute exists is for situations just like this one. Drive-by shootings, when someone shoots into a car while someone's occupying that car. That is criminal damage to property in the first degree, because you've damaged property that endangers somebody's life. A drive-by shooting of a home, someone shooting into an apartment door, someone shooting into any wall that someone's on the other side of. That's what this charge is for, ladies and gentlemen. This isn't just some property crime that the state has decided to just kind of shove into a felony murder statute and give it to you because we're just petty and angry. Criminal damage to property in the first degree is created for situations like this one, when you have someone hiding behind a locked door and someone chooses to get a gun, shoot through the door, and endanger that person's life. What makes it a felony murder is if that person dies. Same thing with a drive-by shooting. If you shoot into a car that someone's occupying and the person doesn't even get hit, that's criminal damage to property in the first degree. If that person were to die, it becomes felony murder. That is what criminal damage to property in the first degree is created for. As to the without authority, they are trying to basically get you to find the defendant not guilty of criminal damage to property in the first degree because of the without authority. Because for some reason, Mr. Barron should have known to yell out, "Before you shoot through the door, I do not give you authority to do this. I do not give you authority to damage this door," for her to know not to do it. This is joint property. Ladies and gentlemen, if they wanted to sell the home, she has to get Mr. Barron's permission. If she wants to do anything with the home, he owns it. Their names are both on the deed. It might sound ridiculous, you might not agree with it, you might think it sounds weird, but that's the law. And so, when you took your oath as a juror to follow the law, this is what we are asking you to do, is follow the law. It might sound funky that the without authority means she had to, it doesn't mean she has to ask permission to damage her own door. That's not what that means, ladies and gentlemen. What it means is you can't just go damaging property without authority. They had joint property. The law tells you that you can't do this. That's why she was charged with it. If she was allowed to damage her own door, she wouldn't have been charged with it. I want to talk about the self-defense. And I put a question mark behind it for a reason. And that's because at no point throughout this entire case did this defendant say that she shot Mr. Barron in self-defense. Not once. Not a single time. What she said was, "I wanted to get my phone, so I was trying to shoot the lock off the door, and it must have accidentally killed him." That is called accident. That is not called self-defense. And I gave her many opportunities. When you got that gun and brought it upstairs, were you going to use it to defend yourself? Were you going to use it to try and shoot the lock off? I was trying to shoot the lock off the door. No point does she ever say that what she did, that her actions were to defend herself. She wanted to get her phone. That's what she told you. Again, I don't believe the evidence shows that Mr. Barron even ever had her phone, but if you believe that he did, it's still not self-defense, regardless of if he had the phone or not. That's not the point. The point is, shooting a lock off a door to get your phone is not self-defense. That is an accident. She is saying she accidentally killed him because she doesn't want to have to admit that she intentionally shot and killed Mr. Barron. I want to talk to you about why this isn't self-defense, and I want to go back for a minute, because y'all read a million text messages. I know you're probably sick of them. I know you've seen a lot of them. But Mr. Willis was incorrect when I said that I was going to get up and talk about everything that happened after the shot was fired, because what I want to talk to you about is everything that happened before it, right? Because for her to be in fear for her life, you have to believe that what she was saying about Mr. Barron is true. Mr. Willis was just having you assume that all that was true. But we know that this defendant doesn't know how to do anything but lie. And Mr. Willis conveniently didn't talk about a single one of her statements in Investigator Mefford's interview or on body cam, and there's a reason for that, because they're all lies. And he wants you to just gloss over that. He wants you to just forget about the times that she lied over and over and over to Investigator Mefford, to the deputies, to you, on the stand. He wants you to forget about that, so he didn't even mention it. So I want to talk to you about why we know that everything she said about Mr. Barron is a lie. And this is the crazy thing about murder cases, ladies and gentlemen, is that defendant gets to get up on that witness stand and she gets to say whatever she wants about Mr. Barron. She can tell you these horror stories about him. And guess who's not here to defend himself? He doesn't get to say a single word to rebut a single lie that she got up there and told you. And so in order to figure out if you think she was telling the truth or not, we need to look at the behavior of Mr. Barron and this defendant before that night. Because that will tell you everything that you need to know about what kind of person she is versus what kind of person Mr. Barron was, because he doesn't have the opportunity to get up and tell you himself. So let's look at this text from October 12, 2024. She says, "I'm so wet thinking about sucking your cock." Hello, hello. He says, "I would love that." That was 2 hours ago. Offer is gone. He says, "I was charging my phone." How about October 28th with Meg? The hair incident, ladies and gentlemen. We cannot forget about the twins' birthday party in September when Mr. Barron told his son's wife's daughter, sister-in-law, that she had pretty hair. Enter 2-month argument about that. "I'm worried about you going trick-or-treating with Meg being there. I don't trust her. I hate that I even have to think about this. It is obvious you are attracted to her. Please let me know if you prefer her. I have been through this. It has made me sick all day thinking about it. Men are visual. You are apparently attracted to her. If you want her, go after her. I do not have hair like that. I am older." What does this horribly abusive, controlling man say back? "Baby, please don't worry. I will not go if you wish. There is no attraction on my end." Talk about isolation. David Barron missed the last opportunity he ever would have had to trick or treat with his grandkids because this defendant didn't want him to go because Meg would be there with the pretty hair. Talk about manipulative. Talk about controlling. Talk about isolation. Fast forward a month later, we are still on the Meg situation. He's not in the mood to sext. So he says, "Leave pussy alone for now," but that sets her off. Once again, "We should have phone sex. Pussy needs lots of attention." He says, "I know, but I'm zeroed in on TV. He just wants to watch TV." "Never mind," she says. "After this weekend, I do not think I excite you. Maybe if I have pretty hair." He says, "I am so in love with you." That horribly, verbally, and physically abusive man, that's his response to this out of nowhere argument. "I am so in love with you." She says, "I wonder. I do not have pretty hair. I am not young." He says, you have beautiful hair and are beautiful. "I want you to desire me. You act like we are married and we are not. I have no ring on my finger." What a horribly abusive man he is. So isolating and controlling and manipulative. Keeps going. "I do desire you, babe." She says, "I am not sure. We never text sexually like we used to. We are not married. I think you need some young pussy with pretty hair. Not interested in mine anymore. Barely wanted it this past weekend after not having for 10 days. His response, "I only need you. I'm gonna hug you now to stop this." Wow. He is just a horrible, horrible person. How about December 5th? "When are you going to ask me to marry you? When are you going to ask me to marry you?" She sends that text twice, 8 minutes apart, because he didn't respond in 8 minutes. He says, "Certainly soon." She says, "Why a secret? I'm not 20. Never mind. I don't want to marry. I can survive alone." His response, "What?" I mean, half of the time that this happens, these fights come out of nowhere, and he has no idea what's going on. It goes from "I love you" to "you hate hate me and you don't want to marry me. She's begging him over and over and over again to marry her. But she wants you to believe that while this is going on, remember it's December, the violence is escalating. It's escalating, ladies and gentlemen. She's already been sodomized, raped, beaten, begging him to marry her. Long text, still on December 5th. I don't want to get married. I will take care of myself. I don't care about what anyone thinks, but I do think about you way too much. You do not think of me in the same way. I cannot make another mistake. I'm really good. I will be fine. I always survive. I don't need anyone to take care of me. I need alone time to think this through. You did tell me 2 weeks ago this moved way too ... You said you didn't have time to think about me or getting a ring because we got a house too fast. I'm beginning to agree with you. I'm not the woman for you. You need somebody more dependent on you. You're a good person. He says, I certainly want to marry you and I have the same feelings for you. She says, no, you don't. I'm going to have this discussion again. If you wanted me, I would have known by now. Go find what you want. Well, I thought that he was so controlling of her. I thought that he was isolating her from her family, not letting her see her family. I thought that he was raping her. But she's telling him that she's angry because he doesn't even want to have sex with her because he's not interested. But I thought that she was off hiding in bedrooms during family events because he basically won't let her talk to anyone. December 15th, I know it's really small, but you'll remember this one. I'm not going to read it all for the sake of not needing to, where she says she gets angry because he doesn't respond to her text in 20 minutes. He says, I'm very interested. I thought you were going to sleep. And then he's talking about wrapping her daughter's Christmas present. He says, I was wrapping your daughter's Christmas present. Enter pages and pages of unresponded to text messages from Suzanne because he didn't respond to her in 20 minutes when she said that she wanted to be writing his whole hard cock squirting all over him. Enter pages and pages of yelling by Suzanne to him because he didn't respond to her for 20 minutes to that text. But I thought he was so controlling and manipulative and abusive. January 13th, at this point, he's already, we know, pointed the gun at her, according to her, raped her, beat, strangled, all the things. I do love you. I'm struggling with this, trying to understand what happened and why. I feel like perhaps I'm not all you need. You were the one thing that was solid in my life. I want to believe so hard that Lilia or Laura mean nothing to you. Let's be patient with each other, and I know we can get through this. And he says, yes, we can. She doesn't say, you meant everything to me until you beat me, raped me, strangled me, and pointed a gun to my head. I understand those were the two rules, right? Apparently, she's allowed to yell at him for literally everything else he does, but she is not allowed to mention the physical abuse, so she just, leaves those out of the continuous rage texts to him. This continues. I need someone that fits me, that lifts me up, I feel inadequate with you. I am not enough. I feel unwanted. I feel like if I let this go, that you're texting them every day and talking to them on your ride home and enjoying their company. I'm never enough. Please do what you need to do. And what's David's response? Because don't forget, if she tries to leave him, he's going to kill her, right? That's what she wants you to believe. If you leave me, I am going to kill you. What's his response? Okay, let's end this. You will never trust me no matter what I do or say. There's nothing that I can do to satisfy you. Yikes. He's super abusive and manipulative and angry and controlling and threatening. Then all of a sudden she starts to dial it back because she doesn't want to leave him, right? Because she's so desperate and obsessed for love. So the second he mentions breaking up, now her tune starts to switch. I feel all alone. I know you never understand. I thought you loved me. All those things. He says, I don't care for anyone but you can't understand. I won't come this weekend and we'll hire an attorney on the house situation. He's just done with it. He's tired of the same argument over and over. What he did wasn't right, but either break up with him or try and move past it. But to do what she's doing, he can't take it anymore. Please call me. Don't hire an attorney. Please call me. But he's so manipulative and controlling and obsessive and abusive. She's the one who won't let him go. She's the one begging him not to leave her. January 21st, all these texts, I'm not going to read them all. It's just a ginormous pages and pages rant without any response from David about how heartbroken she is about Lilia, how alone she is. Who's Lilia? I deserve an answer. Who's Lilia? I fell in love with you. I've been hurt. Why couldn't you just love me for me? Over and over and over, and he doesn't respond. But according to Dr. Elkon, him ignoring her is also abusive, right? And manipulative, because he can't do anything right. If he responds, that was probably abusive. If he doesn't respond, that's also abusive, according to her. When all he's trying to do is just not engage in this crazy, repetitive behavior. February 24th, and again, talking about Lilia, I deserve more. To fight over a woman like that. Over and over, she's fighting about Lilia. He says no feelings towards her. Why do you care for her? I mean, rant after rant. Then let's talk about this text. This is to Dana. This is a text from the defendant to Dana. I'm not going to contact him. I'm tired of chasing. If he wants to come, he can find me. I found out on my own. He was honest. She's talking about that. Then she says, I told him I don't mind him texting other women as long as they're friends. I have guy friends. That's not true. He can't even say a woman's hair is pretty without it turning into a 2-month argument. She told her on January 20th she's not going to contact him. Here's January 21st. Text after text after text after text. How about how much he made her feel safe? There's plenty more than this. I only put in 3. The one I want to bring your attention to most is February 17th. The day after he attempted to anally sodomize her to the point where she had to flee her home in nothing but a t-shirt and was arrested for DUI. Thank you for keeping me calm and wanting to help me. I feel so safe and loved by you. Ladies and gentlemen, I asked Dr. Elkon, you read all 4,000 pages of those text messages, right? Yes. Did you see a single text message, one single text message, where David called her a name? No. Did you see one single text message where David says something verbally abusive to her? No. Threaten her? No. Not one. How many text messages did we see? She's calling him a piece of shit, cursing at him, calling him names, said something about he's a pile of doo-doo, over and over. The only abuser, the only evidence of any abuse is by her to him. That is the only evidence that you have seen of domestic abuse is from this defendant to Mr. Barron. That is it. And I want to talk about the bruises. This was taken by Investigator Mefford. This was taken by somebody who works for the defendant on an unknown date. Look at the difference in those bruises. That's why Investigator Mefford corrected himself and said, once I had a chance to actually compare them, I realized that they don't look the same. They look completely different. It's way darker. How about the tops of her arms? You see that big bruise on the top of her arm? Where is it? I don't see anything. How about the redness down here? Do you see anything on her arm? I don't. Where did those bruises come from? I have no idea. What I do know is they didn't come from Mr. Barron, because everything she says is a lie. What I do know is that she continued to reach in both of these holes to try and unlock the door. Could have caused a bruise. What I do know is that the paramedic came in and said that bruises will show between 20 minutes and 2 hours. This is taken at 6:30 on the left. It's taken at 6:30 the following morning. That's about almost 6 hours since Mr. Barron has been dead. Where's that bruise? It's nowhere. You know what else I know? Is that this defendant spent 3 hours flopping around on the ground on the crime scene, She's leaning up against the corner of the house with her forearms. If you want to watch the body cam again, just to look at her behavior, watch how many times she bangs her arms up against the wall or the corner of that house. Watch how many times she falls to the ground, rolling around. Watch the interview. Watch how many times she's banging up against the wall. She falls onto the chair. She's rolling around on the ground. I have no idea. A million different things she did could have caused some of those bruises, but what I do know is that they look completely different. And I have no idea when the one on the right was taken, or by who. Mr. Willis told you this. This is the law the judge is going to read, but what he didn't explain well was that self-defense, someone is justified in committing murder only when it's necessary to prevent death or great bodily injury. So I want to talk to you about that because let's say, for argument's sake, you believe everything that she said about what happened the night of March 7th, right? Let's say that you believe that he did force her to commit aggravated sodomy on him. Let's say you do believe he put that gun to her mouth. Let's say you believe all of that. You also have to believe that that was the only reasonable way and that it was necessary to shoot that door to prevent death or a forcible felony against herself. And he's right, there's no duty to retreat. There's no duty to retreat, but the reason that retreating comes into play is because is it reasonable and necessary? What does reasonable mean? It's not reasonable to her. It's not reasonable to the defendant. It's reasonable, the belief must be reasonable, that is, a reasonable person would believe that that use of force was necessary. What that means is this objective, reasonable person. You take an objective, reasonable person. Would an objective, reasonable person believe that after being beaten, threatened with death, forced to commit oral sex, a gun pointed to your mouth, would a reasonable person think the best way to protect yourself is to take a gun, walk up to the door where the person who is armed with a weapon that's just been pointed at you, in your mouth, that the reasonable way to defend yourself is to shoot through that door? In what world, ladies and gentlemen, would someone who is in fear for their life by a person who is armed on the other side of that door not think that if I shoot at this door, he's going to shoot back at me? In what world? She is so in fear for her life that she thinks that's the only way to protect herself, but she doesn't even think about the fact that if she shoots through this door, he's going to shoot back at her? What if she had missed and he was still alive, armed with a gun? And she doesn't for once take a second to think that he might shoot back at her? What if she was trying to aim at the lock, shoots the lock off, gets in the door? What was her game plan? He has just beaten her, according to her, forced her to commit oral sex, according to her, put a gun to her mouth, according to her, and she thinks she's going to shoot the lock off, walk in and go, can you please give me my phone? I really want to call an Uber so I can leave. And then he's just going to hand the phone over, she's going to walk downstairs, stand outside of the porch with all the wild dogs, and call an Uber. And he's just going to hang out upstairs and let her rideshare come along and take her away. That is the most unreasonable thing I've ever heard. If you are in fear for your life by a person who is armed with a gun, the last thing you're going to do is follow him up to the locked door and shoot at him. You're going to get out. She's friends with one of the neighbors that gave her a gift basket on Christmas with a handwritten note. But she wants you to believe that it was more reasonable for her to shoot into a room with an armed person than to go knock on the neighbor's door at 1 a.m. She wants you to believe that these wild dogs are the reason that she didn't want to walk out of the house. I'm not making that up. She said it. I'm not even trying to make fun of her for it. That's what she said, so we have to address that, ladies and gentlemen. She wants you to believe that this was reasonable to a reasonable person. That's why I know that David Barron never had his gun. Because if he had his gun, there is not a single chance she would have ever shot into that door. There is no chance that if he had that gun and he had just threatened her with it, that she would have gone up there and she would have shot into that door. Because what if she had missed? You're also going to hear about excessive force. Again, for argument's sake, let's say you believe everything she said about March 7th. You're also going to hear the judge tell you that you're not justified in using excessive force while you're defending yourself. For example, using excessive force would be trying to shoot the lock off the door to get a phone. That's excessive. That is so excessive. To use reasonable force is what you have to find in order to find her not guilty. Shooting a lock off of a door to get a phone is excessive. And you're also going to hear about revenge because you're also not justified in using force basically just to get back at someone. So again, let's say you believe everything she said is the truth. That he made her do all those things, he points a gun at her, you heard what she said. I have a gun too, David. That's what you heard her say. So let's say you believe all those things are true. Now she's angry because he has just forced her to commit oral sex on him. He's just pointed a gun at her. She's mad. I'm going to show you I have a gun too. Walks up the stairs and shoots. That is not self-defense. That is revenge. That is not self-defense. And you should not find the defendant not guilty because of that. What if you find that she does that because of Lilia? She's so angry about Lilia that she wants to get back at him. I have a gun too, David. Walks up the stairs, shoots. That's revenge, that's not self-defense. The judge is going to tell you that. And I want to talk about these. Because at the beginning of this case, Mr. Willis got up and he said, this case is about self-defense. That's what he said, right? But then what happened was he realized that self-defense ain't looking so good anymore. When you have someone who killed someone who's hiding behind a locked door and won't admit that she shot him in self-defense because she's going to double down on I'm trying to shoot this by aiming up here, self-defense isn't looking good anymore. So now we want voluntary or involuntary manslaughter. Just in case. Just in case you guys don't think that it was self-defense, just going to slide this one on in there. Let's throw the spaghetti at the wall and see what sticks. Everything but the kitchen sink. In case you don't believe self-defense, we want to have a backup plan, B and C. Do not find the defendant guilty of voluntary manslaughter and involuntary manslaughter. And here's why. Voluntary manslaughter, the purpose of this statute is if, for example, someone walks in the room and their spouse is actively cheating on them and they already had a gun on them and they're just so immediately filled with rage they shoot the person. That is similar to voluntary manslaughter. Why is what happened in this case not voluntary manslaughter? Because it's only if the person acted on a sudden, only because of a sudden, violent, irresistible passion. What else is important about involuntary manslaughter? Time passing between provocation and the killing. Defense wants you to believe that because David was sending money to Lilia, that she was just so angry, so enraged that maybe you're gonna hopefully at least believe that she just killed him because of that. That's not voluntary manslaughter, ladies and gentlemen. 3 months had passed. Cooled off, this is the law. If someone has had time to cool off, it's not voluntary manslaughter. She's had 3 months of cooling off. She's choosing to stay with him, that's her choice. No one's making her do it. That doesn't mean that every time someone gets mad at a significant other and they can't get over it and months pass and they're hoping they can get over it and they can't, that they're allowed to kill him. Leave. Break up with him. The cooling off period. You can't find him guilty, her guilty of voluntary manslaughter if you find she had a cooling off period. She found out about Lilia in December. We're in March. Imagine, she cannot say, I was so angry at David and I just couldn't get past it and it was just so violent and irresistible passion inside of me and so I decided to kill him. You can't, that is not voluntary manslaughter, that is murder. That is, I was unhappy in my relationship and I couldn't move past it, and instead of leaving, I just decided to kill him. What is involuntary manslaughter? Essentially causing the death without intending to by reckless conduct. Defense wants to relabel the aggravated assault where she walked up to the door, got 6 inches away, aimed in the direction of Mr. Barron and fired as reckless. Ladies and gentlemen, that's not reckless, that's assault. They want you to find her guilty of involuntary manslaughter by reducing what she did, by calling it reckless. That's not reckless conduct, ladies and gentlemen. That is aggravated assault. That is an intent to assault or put someone in reasonable apprehension of receiving injury. I'm gonna shoot you. I'm gonna shoot you. Fires the gun. That's not reckless. That is assault. Do not find the defendant guilty of involuntary manslaughter. It is a cop-out. They're trying to slide those in just in case their self-defense theory doesn't work, because it makes no sense. Hopefully you at least do that. Credibility of a witness. The judge is going to tell you this. Basically, it's your job to judge the credibility of every single person who got up on that witness stand. That's your job. You can do that by looking at the manner in which they testify or their lack of interest in the case or their interest in the case. So let's look at all the witnesses you heard from the state. All the officers have absolutely no interest in this case. They're just doing their jobs. Think about the manner in which they testified. Let's talk about Evan Barron, because they really attacked Evan. Mr. Willis really attacked Evan in his close. He said that Evan told you who the victim really is. I don't know what testimony that he was listening to when Evan testified, because what I heard Evan testify to about the night of December 28th is that she called him frantic, yelling that she pointed a gun at him, at David, that David got the gun away from her, that he was trying to leave, and that she had his keys and had locked herself in the closet or bathroom. It keeps going back and forth. I don't know which one it was at this point, because everyone said both. Closet or bathroom. And that he heard his dad yelling because he wanted to get his keys so he could leave. And then what Evan testified to was that after they made sure everyone was okay, that dad is safe at a hotel because she finally gave him his keys back, and after he made sure Suzanne was okay, he told Suzanne, we don't like this whole Lilia thing, we've known about it, we're going to talk to him about it. This wasn't some intervention for the victim's anger and all these things that Mr. Willis was talking about. It was a complete misrepresentation of what Evan said, and Evan kept trying to correct him on the stand too. I vividly remember that. He kept saying, you were going to have an intervention though with your dad after this, right? Yeah, an intervention about Lilia. We wanted to talk to him about Lilia because we didn't want him sending money to her. But an intervention, right? And then he just wrote the word intervention. Completely misrepresenting what Evan said in the testimony. Completely misrepresenting it. And then the whole spare key situation, did you see any keys on the counter? Evan said, clear as day, we found them in the junk drawer, in the pantry. I don't know why we were showing all this body cam to show that there were no keys sitting out on the counter. No one said that the keys were sitting out on the counter. He said they were in a junk drawer. They're just trying to make Evan look like a liar, and to be honest, of all the family members you heard from, Evan was the most honest. He has every reason to come in here and say all these horrible things about the defendant because she murdered his dad. But guess what he did? He told you the truth. I was happy for him. They had a lot in common. They liked football. Family vacation was great. We all got along. When you're judging the credibility of witnesses, part of what you're doing is judging the manner in which they testify. He had every reason to come in here and think of anything to say to shame her and to put her down because she killed his dad. And he told you the truth. We liked her. I didn't like the Lilia thing either. I wanted it to go away. I think the only bad thing he said about her was made me a little bit uncomfortable that she was reaching out to me that much about Lilia. That was it. How about Beth? Beth has known David for 50 years. Married him for 23. This defendant knew him for 10 months. Married for 23 years, has known him for 50, remained friends with him up until the day that he was killed. And what did she tell you? He was a peaceful, kind person. How about Laura? Married for over 10 years, friends for 25, remained friends up until the day he died. What did she tell you? Same thing. Let's talk about Dana and her kids. How about the manner in which they testified? The rehearsed robotic testimony you heard from them. How about the story that one of them said about the defendant being force-fed a bowl of ice cream by David? That was the example that they gave about how abusive he is. He gave her a big bowl of ice cream. They're trying to pull anything out. They don't want their mom to be convicted of murder, and I don't blame them. I don't blame them. They're her kids. They did nothing wrong. Dana did nothing wrong. It's her sister. But when you're judging their credibility, that's something for you to consider. The manner that they testified in and their interest in this case. How about Dr. Elcon? I really don't want to spend too much time on Dr. Elcon because I personally don't think it's worth it. Because everything she said was blowing my mind, if I'm being honest. Everything was consistent with Mr. Barron being an abuser. Without any follow-up, without any verification, she just took the defendant's word for everything. She didn't even bother to get prior mental health records of the person she's trying to diagnose with PTSD. Didn't even get mental health records. That is insane to me, ladies and gentlemen. That is insane to me. And there are hundreds of real victims of domestic violence that walk into this courthouse every single day. Hundreds. She owes every single one of them an apology. She is a disgrace to victims of domestic violence. She is an absolute embarrassment to real victims of domestic violence. So is Dr. Elcon. Because how dare she? I asked her, there's a literal picture of David with the scratch on his face, with the defendant admitting that they got into a fight and he scratched her, and she's like, oh, that was just a scratch. Imagine if there had been a picture with a scratch on her face, and what we would have heard about that. Imagine. Not even putting in her report that this defendant told her she had thoughts of suicide the night she murdered her boyfriend. Didn't think that was important to put in her report. Not putting in her report that this defendant told her allegedly that he made her basically perform oral sex on him the night that she killed him. She's diagnosing her with PTSD for trauma that Mr. Barron inflicted on her allegedly, and she didn't think it was important to put in her report that the night that he was killed, he forced her to perform oral sex on him. How was that not important for your report? First time I heard about it was in opening statements because it wasn't in her report. First time I heard about the suicide was in opening statements because it wasn't in her report. Jim Persinger is very impressive. He is a very credible witness. He is very impressive, and I do not think he got up there and lied to any of y'all. I just put him up in this slide because I didn't really understand the purpose of his testimony. I didn't really see how it was relevant because the phones went up the stairs 12 seconds apart. He attributes that to a glitch, or not a glitch, but a lag in the phones. How do we know that they didn't just go up the stairs 12 seconds apart? He's just making an assumption. Could have gone up the stairs 5 seconds apart. Also, it doesn't really matter if the phones went upstairs at the same time because we don't know who took them up the stairs. Could have been her. Didn't tell us anything. How about the credibility of the defendant? I think I've talked about it enough, so I'm going to breeze through the fact that this defendant is a compulsive liar. But these are all the lies that I could just think of on the top of my head that we know for an absolute fact are not true. We know that David didn't shoot at her, regardless of how many times she said he did. We know she flushed shell casings, regardless of how many times she said she didn't. We know she fired his gun. We know he wasn't drinking. We know that that gun was not next to his body. We know that the holster was not next to his body. And we know that that whole kitchen store was a total lie. What about the fake ER visit? She was lying to y'all about that till we took a break, and then she gets back up on the stand, and all of a sudden, oh yeah, I'm sorry, that was a lie. Because she'd been caught. Couldn't lie about that one anymore. How about the fake man? Tried to lie about that at first, then realized she'd been caught with that too, so then she gave up on that one. Fake law enforcement coming to talk to her at St. Simon's. She's manipulating him. Imagine if Mr. Barron had done that and texted Suzanne, oh, I'm vomiting up blood, come see me. Oh my gosh, the things we would have heard from Dr. Elcon about that. I want to talk to you about this. Mr. Willis barely touched on it, probably because it makes absolutely no sense and no one really knows what to make of it. She wants you to believe that those shots from 12 to, that is a foot. This is 12 inches off the ground. It's from her committing suicide. In what world, with a gun like this, was she laying on the ground? Was she sitting on the ground? She had no blood on her back. She had no blood on her butt. How was she 12 to 16 inches off the ground with a gun like this, tries to fire it once? Oh no, it didn't fire. Tries to fire it a second time. Oh no, it didn't fire. Tries to fire it a third time. On the third time, whoop. Oops, let me try again. Whoop. In what world does that make any sense? That is the most insane thing. She didn't even really go into detail about how she did it because I don't think she knows to this minute how to explain how those shots fired from 12 inches off the ground were from an attempted suicide. But she wants you to believe that that's the reason why she fired David's gun out the door and why she flushed the shell casings, because she didn't want anyone to know that she sat here and just continuously did that. I want to show you the verdict form very quickly. Judge, may I have the, This is what the verdict form is going to look like. You're going to have it as well, and I want to show you and explain so you're not confused because there's a lot of options. This is count 1, malice murder. To put an X right here, you would have to believe either that the state did not meet all of its elements, which we have, which means the only other reason you would put an X here is if you find that the defendant acted in self-defense and was justified in killing Mr. Barron. That's the only reason to put an X right there. If you find that she maliciously killed the defendant, intended to kill him, this is where you put your X. Line 2. Every count, line 2 is going to be what the defendant is charged with in the indictment and what the state is going to ask that you find the defendant guilty with beyond a reasonable doubt. Line 2, malice murder, guilty. On to count 2. This is the felony murder based off of aggravated assault. Guilty. What are these below it? These are their plans B and C. This is the, oops, self-defense doesn't really make any sense. Hopefully maybe they do manslaughter instead.
Judge, I have to object. I've allowed her to state this many times. The charges are from the court, not from the defense, so I'd ask her not to make that inference. I object.
I don't think there's anything improper about this, Judge. They asked for them to find the defendant guilty of voluntary manslaughter, involuntary manslaughter, and I'm asking them not to.
I most certainly did not.
Without commenting on the evidence, the state is welcome to give their opinion on what they would like for the jury to cross-check, whatever. That's perfectly reasonable. Without commenting on the evidence, the court has created the documents that are being referenced, and it's the court's, again, not making any comment one way or the other, but it's the court's document with input from the parties with ultimately my final. So I will overrule the objection with that explanation. State may proceed.
Thank you, Judge. Sounds like they're not asking you to find her guilty of voluntary manslaughter, involuntary manslaughter, so that makes that a whole lot easier for y'all then. Count 3, guilty of felony murder based off of the criminal damage in the first degree. Again, the second line on the verdict form. Count 4, again, only this if you find the state has not met the elements beyond a reasonable doubt or self-defense. If not, we move on to aggravated assault. What's below it is reckless conduct. Again, a lesser included that the defendant is not charged with. This is a cop-out. This is what the state's asking you to find the defendant guilty of. Count 5, first degree damage, criminal damage, property in the first degree. Second line, again, reckless conduct is a plan B. And lastly, the last two. There's no other options other than guilty or not guilty as to counts 6 or 7.
Laptop.
Yes, please. Ladies and gentlemen, any which way you spin this case, the defendant is guilty. There's no excuse, there's no justification, and there's no defense for walking up to a door, getting 6 inches away, and killing someone who's hiding behind it. And on top of that, her actions after the fact show why this was malicious and why there was intent. Because not only did she kill Mr. Barron, but then, while she stepped over his dead body, she altered the scene. She tampered with the evidence. She planted evidence. That is malice. After everything you've heard in this case, there is no room left for any doubt. There's just not. And at the beginning of this trial, Mr. Willis did. He put that picture up, the smiling selfie of the defendant on the beach, and he said, "You're never going to get to meet her. You're never going to get to hear from her. She's gone." And then you know what he just said? She's gone almost as much as James Barron. That is insulting. She's sitting right there. She got to see her kids yesterday. She got to see her smiling kids. They got to see her. Guess who you didn't get to meet? Guess who you're never going to get to meet? Guess who's never going to get to see his smiling kids? And his kids are never going to get to see him. You are never going to hear from him. He is never going to get to come in here and defend himself from her lies. She took that right from him, and she took the privilege from you to hear from him. You will never get to meet James Barron. There's only one victim in this case, ladies and gentlemen. And I promise you it's not the person who took a gun, brought it up, and shot through a locked door at someone hiding behind it. That's not the victim. This is the victim. He might not ever have the opportunity to come in here and tell his side of the story, But fortunately for Mr. Barron, the evidence speaks louder than he probably ever could have. And so that's where you come in, ladies and gentlemen, that's where you come in. Because even though David's voice was taken from him by her, your verdict can speak volumes for him. So I'm going to ask that you follow the evidence, you ignore the lies, and you find this defendant guilty. Thank you.
In a few moments, I'm going to begin reading the jury instructions. If any members of the gallery wish to